Hey all, Professor Tracy back with another lecture on negotiable instruments. This one is a double topic, although these are definitely closely related. So these are about checks and the idea of a check being properly payable or not, and then wrongful dishonor of a check. There's quite a bit to run through here, so let's jump right to it. So first we'll look at properly payable. So let's look and just remind ourselves of how a check works. So we've got Bo. Bo is going to go to the shop here, the grocery store, and he enters into a contract, right, where he's going to pay the shop $300. They're going to deliver groceries to him, and he writes a check to fulfill his obligation to pay them $300. So as we recall, the person who issues the check is called the drawer. So Bo is the drawer of the check here, and his bank at which he has an account that he's drawing on. And remember that a check is in order to pay, and as opposed to with a note, we said that a note is a promise to pay. And so the order with a check, that order is directed to the bank. Remember that bank that Bo is ordering to pay, and in this case, because it's an ordinary check, it is in order to pay funds out of his own account at the bank. And they are called the drawee bank. So we have the drawer, the drawee, and then the check will be payable to the shop, right? He's ordering the bank to pay the shop, and so the shop we label the payee. And so we have the three parties to a check, right? The drawer, the drawee, and the payee. So in this case, we're moving forward with our fact pattern here. Bo has given the check and the shop has taken the check. And remember that when the payee takes the check, that suspends his obligation, Bo's obligation. It's frozen or suspended at that point. It cannot be sued on. It's not discharged, it's suspended at this point. And now the shop is endorsing, giving a blank endorsement on the back of the check, and it is negotiating that check or depositing it in its own bank, right? The shop it has an account at the depository bank here, and it is negotiating the check to that bank. And so they've already endorsed it in blank, so it's payable to bearer. And so if the depository bank has possession, then they will be a holder of that check, right? Because it has to be payable to them and they have to possess it. And so in this case, they now possess the check. It's payable. It was endorsed in blank. One important thing to remember when you have a depository bank situation like this, that even if the shop had forgotten to endorse the check on the back, either with a blank endorsement or a special endorsement saying pay to depository bank, even if they had forgotten, they would still be deemed to be a holder under the UCC. So this is one place where there's an exception that regardless of whether or not shop had properly endorsed the check, the depository bank here would still be the holder either way. So here, then remember that the depository bank they have the check, they will present it to the drawee bank for payment, right? Because remember, it's the drawee that's been ordered by Bo, the drawer, to pay that check. And so it's being presented to them for payment. And so remember that when that occurs, right? So they've presented it, the bank has the check, and the bank has a choice, right? They can either pay that check, that check can be paid, or in which case, remember the ramifications of that. If Bo's bank pays the check, then his obligation is discharged. It's already suspended, but if it's paid, the check is paid out, then his obligation would be discharged. Or they could dishonor it. That check could be dishonored. Dishonored meaning they don't pay it. In which case, the obligation would be revived, right? Unfrozen, unsuspended, revived, such that it could be sued on, right? Because the check was not honored. It was dishonored. So in this case, because of us wanting to look at properly payable first, we're going to assume that the Drawee bank here pays the check. Under B here, Drawee bank pays the check. And there are consequences, right? If we go back here and we say, okay, Drawee bank's going to pay that check, we already said what one of those consequences is, right? That Bo's obligation to the shop is discharged. It was suspended, but if the check is paid, it'll be discharged. But the other thing we have to understand as we're getting into the idea of properly payable is, so here we're showing that it was paid, right? So the obligation being discharged. So they had the check, right? Drawee bank had the check. They get out the money. They pay depository bank who presented the check. At that point, once it's paid, that discharges Bo's obligation. So that's that. But the other consequence is this, that the Drawee bank, that Bo's bank, after paying that check, if that check was properly payable, then the Drawee bank has a right to reimbursement from Bo, from their customer. That right to reimbursement is from their customer because they're paying out the check with their money, and then they have a right to reimbursement from the customer's account. So these things are tightly connected. This idea of a right to reimbursement and the check being properly payable. It's only if it's properly payable that the Drawee bank has the right to reimbursement. So what does it mean that a check is properly payable? What does that mean? Well, we'll see. It means a lot of different things, but there's a lot of parts to what it means, but a lot of them are very quick. So it means, one, that the customer, in our case, Bo, authorized the payment, meaning that it was him who asked the bank, ordered the bank to make the payment. It was authorized by the customer, as opposed to it being a forged check. So if it's a forged check, right, then it's not authorized. That should make sense, right? Because it's not Bo, the customer, signing the check. It's somebody else who is not Bo, and that is not authorized, right? If it's forged, a forged check is not authorized, which means if the Drawee bank were to pay it, it's not properly payable. And therefore, if they do pay it, they have no right to reimbursement, right? If a check is not properly payable and they pay it, then they have no right to reimbursement. It's only if it's properly payable that they have the right to reimbursement. So here, a forged check is not authorized, not authorized. Now, this is important to understand. If the reason there is a check that's stolen, for instance, and then forged is because of Bo, the customer's negligence, maybe he had signed a bunch of checks ahead of time to save time. He had a bunch of blank checks around, or he was otherwise doing something to make it likely that his check would be stolen or forged, then in that case, if it's caused by the customer's negligence, and the bank pays it, then it is properly payable. It's authorized if it's caused by his negligence, right? Ordinarily, the authorized thing's straightforward. If it's, Bo or any other customer, if they sign the check and make it out, if the payment is authorized by them because they're the ones asking the bank to make the payment. But if it's forged, no. But if the whole situation arose because of the customer's negligence, then we deem it to be authorized and therefore properly payable, and there would be a right of reimbursement. And related to this, whether is the payment authorized by the customer, it doesn't have to be the customer themselves signing. If they have a representative signing, that's fine. Anybody who signs with the with the customer's permission. So if, for instance, you gave a check to somebody and forgot to sign it, and you told them over the phone, hey, go ahead and sign it for me, that's fine, that would be enough, even though you didn't do the actual signing, the customer didn't do the actual signing, you authorized it, so it's fine. So if it's done with the customer's permission, it's authorized, it's properly payable, and there's a right of reimbursement. What about this, that the Drawee bank must have paid the PEAT, right? To be properly payable, the check, they have to be paying the PEAT. So remember what we said is that it's a holder of the instrument, so a holder of the check, or a transferee of a holder. Remember that under the shelter rule, that the transferee of a holder or holder in due course, it does not necessarily, even if they don't independently have the status of a holder or a holder in due course, they would nonetheless have the rights of a holder or a holder in due course because they took the instrument from a holder or a holder in due course. So they would have the same rights. Then the third category, remember, and we looked at this in detail in the last lesson, is that if the person was the owner of an instrument that got lost or stolen or destroyed, they retain the right to enforce it, right? So they were the owner of a check, for instance, it got stolen, they retain the right to enforce it, so they're a person entitled to enforcement. So if we look at an example here where we're talking about whether or not the Drawee bank is paying the person entitled to enforce, here when the depository bank presents the check, they are a holder of that instrument, right? They're a holder of that instrument. Because remember that here, our fact pattern was that the shop gave a blank endorsement on the back, then gave possession of the check to the depository bank. And so they have possession and it's payable to them. Remember that even if they wasn't properly endorsed, we have this exception under Article 3 that says they would still be a holder because the depository bank for the payee. So they're a holder, so that means they are a person entitled to enforce the instrument. So the Drawee bank, for them to pay this bank, is fine, right? Is fine. It's properly payable to the depository bank because they're a person entitled to enforce. But what about this situation? And we'll pick up the fact pattern here after Bo has already given the check, right? And the shop has taken it and that has suspended his obligation to pay the $300. We're picking it up there. And so while they have the check, along comes Bob. And Bob, in this case, is the thief, right? He's taking a turn for the worse. So he steals the check from the shop, and then he has stolen this check, right? If we assume that, let's assume it was endorsed in blank already under that we're picking up after that as well. So it's already been endorsed on the back and blank, so it's payable to bearer. Now that means it's payable to Bob. Right? And so if they present it, then, well, you know what? Scratch what I just said. We don't want it to be a bearer instrument. So assume they did not endorse it. They did not endorse it yet, and that he just stole the check and then he's presenting it for payment, then he would not be a holder. He's not a transferee of a holder, right? Because he just took it, right? Nobody transferred it to him. He just took it from them. And he's not the owner of an instrument that was stolen and destroyed, right? He retains the right. That would be the shop, not him, right? He's the one who did the stealing. So in this case, he's not a person entitled to enforce it. So were the bank to pay him when he presents the check, that would not be properly payable, right? They would have no right to reimbursement, and that they would have to bear that loss. Although we'll see they have a chance of recovering in some other way, but we'll talk about that when we get there. The check can't be altered, and we'll explain more exactly what we mean in just a second as we launch into it. So the bank, we're going to assume here, what the fact pattern we're initially looking at here is that the bank pays an altered check to a holder. So the check's been altered and they're paying to a holder. So here, as you would expect, when Bo gives the check, this check is payable to the order of shop, and it's for $300, right? Because that's his obligation. So makes sense. It's payable to them. It's for $300. What we mean by an alter, whether it's altered, is this. If, let's say, the shop thinks they're clever and they go in and change it, add a zero, make it look like it's $3,000. So they alter the check. And then we're going to jump forward in time to where the bank, this altered check is in the hands of the depository bank. They present it for payment to the Drawee bank. It's being saying, please pay this check. And they have the check and they're going to pay it out. So what does that mean? So here, with an alteration, they only have a right to reimbursement for what was authorized. Bo's authorized payment, what he authorized the bank to pay, was $300, not $3,000. So if they paid out the full $3,000 from the altered check, then Bo doesn't lose that. That is on the bank. The only thing they can get from Bo is the $300 he authorized. That's the amount that's properly payable. Nothing else, because it wouldn't be authorized because it's been altered. Now, what about the completion of an incomplete instrument? The completion of an incomplete instrument. This comes about because people do things like signing a check and handing it to someone without having put in maybe the money amount, or they didn't put in the name yet of the payee, right? Maybe they just signed it. But completion means that they're completing it. The person completes the instrument and then it's presented for payment. So here, like this, if it was just missing the amount on Bo's check, and the shop decides, oh, instead of filling it in for $300, which is we're pretty sure what all that Bo intended, we're going to fill it in for $5,000. $5,000. So they fill it in for $5,000. We're going to skip forward in time again to the shop's bank here. The depository bank has it, is presenting the check for payment. And in this case, what happens? If they pay it out, assuming the bank paid it in good faith, meaning there was nothing that raised suspicion about the whole thing. They just saw the check. It was completed, but they pay it out, then they have a right to reimbursement for the full amount of the $5,000. Because in this case, we can't go back and go, well, Bo only authorized the payment of $300. No, he left it blank. He left it blank. It's on him. So if they pay this out, if it's completed by the shop and then the bank pays it out in good faith, then they're entitled to reimbursement for the full amount. No, there can't be a stop payment order. If there's a stop payment order, then the check is not properly payable. So again, he's already paid his check, right? The shop's taken the check. And here, after he's paid, they have the check. Bo looks at these groceries. They've been delivered. He's like, these groceries are terrible. So he calls up his bank, the Drawee bank, and he says, please stop payment on check 2187. I wrote it to shop on December 30th. Yes, sir. Check 2187. We understand. Will do. Bye. So they have notice, right? He just gave a stop payment order. They have notice of, he's identified the check, told them to not pay it out, right? That's what a stop payment order is. And so we fast forward in time to when the bank has the check again. It's presenting it. Remember, Bo's given a stop payment order. So it's not properly payable because there's a stop payment order in effect. If there's a stop payment order in effect, then it's not properly payable. If they were to pay it out, they would not be reimbursed. The Drawee bank would have no right of reimbursement, right? So as I noted right there. So, but you need to be careful here with a stop payment order because and this is obvious, but it requires notice to the Drawee bank. You've got to give them notice. It's not enough to just think about it or to tell for him to tell the shop that he stopped payment on it. He's got to give notice to the Drawee bank to tell them to stop payment on the check. And that notice must come from someone. That order, right, that stop payment order has to come from someone who's authorized to draw on the account, not some random person, right? It's got to be somebody who actually has a right to draw on the account. It can't be somebody, it could be somebody acting at your behest. You've authorized them to act, but it can't just be somebody else who claims they have some sort of right to the account, but they don't. So for instance, if you had like a situation with say a messy divorce and there was an account which was in one person's name, but the other person was claiming they had a right to that account and they were calling the bank, if they're not actually authorized, if the account is not in their name and the bank is, she or he is saying, stop payment on this check or that check, they shouldn't listen to that person. So it's got to be from someone authorized to draw on the account. And when you give notice, the customer must reasonably identify the check. Ideally, you're giving a check number. You can identify who it's to and the amount, but, reasonably identify, give enough information to the bank so they know what check you're talking about. And it must be before the bank has paid the check. It has to happen before they pay. Once they paid, you're too late. And the UCC goes further. It says, Article 3 says it must be within a reasonable time before the bank pays. You can't do it, very, very last minute. And you're like, well, you haven't paid it out yet. You've got to give them a reasonable amount of time in order to make, to be able to handle it and not pay it. So that's important. There can't be a stop payment order in effect for the check to be properly payable. So what about post-dating? Post-dating. So what is post-dating? Well, the first thing to know about post-dating is it's only effective if the customer gives the bank notice. And that is contrary, I think, to a lot of the received wisdom around post-dating on checks that a lot of people have conceptions about. But remember, so here's an example of what wouldn't be effective. So if Bo had given a check to the shop, and if the date of this transaction is December 19th, but he had dated the check the 29th, 10 days later. So post-dating, a lot of people like to do this because they think it's, buying them time, or they can, check out something before the check's going to be paid, that kind of thing. But in this case, he's got 10 days, right? He's December 29th. The transaction's occurring on the 19th. So here, we're going to fast forward in time. They're presenting it. So, and the bank pays it out. Bo's bank, they're going to pay it out right away. That's fine. If they paid, again, in good faith, they always must pay in good faith, then they have a right to reimbursement, even though it's paid early, right? It's quote unquote paid early. Because why? He didn't give notice. He just post-dated the check and gave it to the shop. And the reality is that in modern banking, these banks don't actually look at the checks very closely. All of it's very automated electronic process. So part of the reason you need to give them notice is they need to go grab the check and identify it and deal with it in particular, because they may not even be aware that it's post-dated. If they are, then potentially they're not paying out in good faith. But oftentimes in modern banking, they are not going to know because they're not even looking at the date on the check because of the way the system works. And so in this case, he hasn't given them notice, right? He has to give them notice for the post dating to be effective, for them to wait 10 days to pay it. Then he has to give them a heads up. He didn't do that. So here's what would work. Pretty similar to a stop payment order, right? We're assuming still the same thing here. The check is post dated and Bo gets on the horn and he calls his bank. I just used a post-dated check. It's check 2187 for $300. I used it today, December 19, 2022, but I dated it December 29, 2022, right? So he's identifying the check, right? And again, the bank says, yes, sir, check 2187. Got it. We'll be sure to wait until December 29, 2022 before we pay it. So we got this. Now they have notice. So when it comes forward, they should not pay it right away. It's now not properly payable until the post-dated date of December 29, 2022. So that was an example of an effective post-date, but you got to give them a heads up. If you don't give them a heads up, it ain't effective. So if they pay it early, remember, if it's not properly payable, which it wouldn't be if they pay early, then they have no right to reimbursement. So here's another, what about, they can't have notice of the customer's death or incompetence. Death or incompetence. But the UCC is actually quite generous with this rule. So let's say that Bo has already transferred, issued the check to the shop. They've taken it, it's suspended his obligation, and then poor Bo dies. So Bo's died here, may he rest in peace, and we're gonna fast forward in time. Then at that point, the depository bank's presenting the check again to the Drawee bank. They can pay it until they have notice of Bo's death. They can pay it, it's still properly payable. And the UCC goes even further. It says for a period of 10 days after he died, they can continue to pay things that are outstanding. Any checks, certified checks, other things, anything they're paying like that, they can do that for 10 days and it still be properly payable. Now, after that window, right after they have notice, and it's more than 10 days after he died, then it's not properly payable, right? But it's pretty generous, right? And it's not 10 days after they have notice here. They have notice, but it's 10 days after his death. So for whatever period of time, right? So if they find out about his death and it's already 5 days later, then there'd only be another 5 days they could pay out. So what about a deposit contract? So often when you open an account at a bank, you have a deposit contract. So one of the things that is important to look at is, does the deposit contract allow payment of this check? Does it allow payment of this? That would be another thing to say it's properly payable or not. So it's possible, here we went back to our example of Bob having stolen the check from shop, And so Bob, being the thief here, he presents the check for payment. He's not a Pete, right? We already said he's not a person entitled to enforce the instrument, and thus it's not properly payable, and thus if the bank paid it out, they would never write a reimbursement from Bo's account. But you could have an agreement, right? Bo could have an agreement with his bank that actually says it's okay. It allows payment in circumstances like this, and if it does, then it would be properly payable. So the agreement can change the way the ordinary rules work. That being said, right, or I'm saying, yes, that's how it works, but here's what you need to know, which is Section 4103A says, an agreement may set reasonable standards for the bank, but may not disclaim the bank's obligations of ordinary care and good faith. So they can set standards and limitations and say we can do this or that. But if it allows them to be negligent or it allows them to act in bad faith, then that agreement is not okay. It's not going to be upheld. So what about NSF, non-sufficient funds, NSF? The one thing to know here, I think received wisdom might be that, well, that check's not properly payable if you don't have sufficient funds in the account to cover it. And that's not the case. It is properly payable, even if there isn't sufficient funds in the account. So let's see. So what if Bo lacks sufficient funds in his account to cover the $300 check? So here's what we're looking at, right? Is the check is being presented to Drawee Bank. He doesn't have $300 in his account to cover the check. So what happens? Now, they could dishonor it. So it's important to understand when the customer, the drawer Bo here, doesn't have sufficient funds, it would be okay for them to dishonor it, which we'll get into in the second part of this lesson, which is about wrongful dishonor. We'll see that, well, this wouldn't be wrongful, right? They can dishonor the check if there isn't sufficient funds in the account. But they could pay it because it's also deemed to be properly payable. So they could do either one. So long as it does so in good faith. They can pay it out. So if they pay it out, it would be considered properly payable. So here's the other thing to know about this insufficient funds. So the bank can choose, the Drawee Bank can choose the order in which it pays the check. So what we're assuming here is there are multiple checks outstanding that come in that for the bank to pay, that are presented for payment, and let's assume in this case that there's a balance of only $500. There's a balance of $500 in Bo's account, and there's a $500 check, a $200 check, a $100 check, a $50 check, $40 check, $30 check, and a $10 check. Right? So we could look at this and say, okay, well, what order would they pay them? The bank here can decide the order. It doesn't have to pay all the small ones first. So it can decide to pay the big one right away, and then all the others would be overdrafted, right? There would be insufficient funds, and they can charge the customer a fee, right? A penalty for overdrafting, and that's fine. The UCC allows that. So they can charge that hefty fee for each of those, and that's okay. So what they call that high-low posting. When they're posting the checks, they're going high to low, and that's allowed. That's allowed for them to do. But keep in mind, when there's insufficient funds, they can penalize the customer. But also, if they pay them out, they're still properly payable because it's up to the bank as long as it's acting in good faith. So what about a stale check? What's called a stale check. So if a check is presented more than 6 months after its date, a check presented more than 6 months after its date is considered stale. It's stale. So in that case, the bank, again, it may pay it. It is properly payable even if it's stale, assuming there's nothing about it that would make it appear that they shouldn't pay it. So they can do it. Why? You might say, well, why? Well, one reason is the customer ordered payment, and assuming there's not a stop payment order, then presumably the customer still wanted it paid, even though it's been outstanding for a while. So they ordered payment, they didn't stop payment, then it's not crazy to assume that that is in fact what the customer intended, even though it's an old check. So, and just as we were talking about with post-dating, the UCC understands that in modern banking, the banks don't look at the date on the check. So it's likely they don't even know that it's a stale check, which reinforces them paying out in good faith, right? You're saying, did they pay out in good faith? Well, yeah, because they didn't even know it was stale, because they didn't even look at the date, because that's how it works. So the fact that we can make an assumption that they're paying out in good faith because the customer ordered it and there was no stop payment order, and that's just the way banking works. They probably didn't even have notice it was that it was stale. So those are all the requirements. There's a lot of them for a check to be properly payable. Those are the things that must be true, all of them. And remember, if the check is properly payable, then the drawee bank has a right of reimbursement. If it's not properly payable, then they have no right of reimbursement. Remember that reimbursement is from the customer's account. So, well, what can they do? What if they pay out something that's not properly payable? Say they make a mistake and they pay out something that's not properly payable, and now they have no right of reimbursement. Can they get their money elsewhere? Again, assuming it could just be they made a mistake. So the drawee bank may use subrogation when there's no right of reimbursement, meaning that it can stand in the shoes of another party and collect. So here's an example. There's 3 requirements: that the bank paid the check by mistake, not purposely, right? Not looking at it and going, oh, yeah, it's not properly payable, we're just going to pay it anyhow. But it was a mistake that they paid it out. And that the bank is now facing a loss. And this is often going to be met, right? Because if they paid it out, it wasn't properly payable, then they have paid out money for which they have no right of reimbursement, so they have a loss. They have a loss. But here's the thing, the question is there a party being unjustly enriched? Are they being unjustly enriched? In a lot of cases, it could be the drawer, right? Because it might be the case that the drawer ordered payment of, say, some sort of debt or obligation, like Bo paying his $300 obligation, but for some reason the check wasn't properly payable and they pay out on it. Well, here's the thing that check was paid out, right? So Bo benefited, right? He got his groceries, he got the bill paid, he's taking a windfall there, but nothing's coming out of his account because there's no right of reimbursement. So in which case they could be subrogated to the other interest, right? That in saying you have benefited without gaining, so we can sue you for restitution and get that amount to try to cover it, right? Because they've benefited and without having to pay. So we said the second subject we're looking at is wrongful dishonor. And the basic rule of wrongful dishonor is that a drawee bank is liable for wrongful dishonor if it fails to pay a check that is properly payable. So this is kind of the reverse or the flip side of what we've been talking about. We've been saying, well, what happens if they pay something that is not properly payable? Right? We said, well, they have no right of reimbursement. Maybe they can be subrogated to some other party and get restitution. But that is that's the one side of it, right? That there is a payment of something that wasn't properly payable. Here we're saying this check is properly payable, but the drawee bank dishonors it. They dishonor it. And it's important to understand who it is that's hurt is the bank's customer, right? So when the depository bank, this is Bo's check, right? It's being presented to his bank. And when they take the check, and if they fail to pay it, even though it's properly payable, right? It's properly payable. That means they should pay it. If they don't, then that's wrongful dishonor. And Bo can sue for all damages proximately caused by the wrongful dishonor. So the cause of action or the injury here is to the drawer, and it's the drawer that can sue for wrongful dishonor. There, because the drawer is the one that's injured. And this is different than so much of what we've talked about over the course of this course over the winter intersession. Is we've looked at asking ourselves about amounts that could be paid on an instrument or on an obligation from a contract, but this is an action for damages, consequential damages that flow from the drawee bank's wrongful dishonor. They had a properly payable check and they wrongfully dishonor it. Well, why does this happen? Why do banks wrongfully dishonor checks? Here's a few quick reasons. Reason one is that the customer makes, deposits money in the account, the bank fails to make it available in a timely manner, and then they dishonor a check that's been written by the customer, right? So they grab the check, they didn't make the funds available in the account in a timely way, and therefore when they look at the check, they're like, well, there isn't sufficient funds, and they're allowed not to pay it, right? We said if there isn't sufficient funds and there's going to be an overdraft, that we said that the bank could pay it and it would be properly payable, or they could not pay it and it wouldn't be a wrongful it wouldn't be a wrongful dishonor. But in this case, because they messed up by not making the funds available in the time span they should have, that caused them to wrongfully dishonor a check when there were funds there and there should have been funds, but they messed up. Another reason here is sometimes a bank in its contract, we talked about deposit contracts, will say that it will pay overdrafts up to a certain amount. If they suddenly decide they're not going to, even though the contract says they will, that would be a wrongful dishonor. If they dishonor the check instead. Sometimes the bank will freeze an account because of activity on that account that it thinks is suspicious. And if they don't have sufficient reasons to actually freeze the account, then that results in wrongful dishonor of outstanding checks. Then another reason would just be simple error, right? It's a mistake. Nobody intended to dishonor it, but they did. It was just a straight up error. That is often a reason why a check is dishonored. I've mentioned this earlier when they're listening to the wrong person, like with a stop payment order. that if they are listening to somebody who isn't authorized to draw on the account, so often it may come up with, like in the midst of a divorce or something like that, where someone's claiming they have some sort of stake in an account when in fact they do not, and the bank shouldn't be listening to that person, and they do, and that means they're dishonoring a check that they shouldn't be, and that's wrongful dishonor. So it's consequential damages, right? That's what happens. So bank fails to pay. We said he can sue. He gets all the damages caused, right? So what are the damages he could get? He could get zero, right? Sometimes the consequence is no big deal. It's like, well, no big deal. I'm not late or anything with this payment. I'll just write out another check. No big deal. And in which case, there are no damages, right? If there's zero, there's zero. But they could be really large, right? That if the check is absolutely crucial to the business, and that the business, they go out of business because the check was dishonored. You could have your car repossessed or something because the check is dishonored. You could be, if you're uttering a bad check, it's a crime, so you could be arrested. So if it appears that you're writing bad checks. So on and on. The stakes can be quite high. So you can get things like pain and suffering resulting from the wrongful dishonor. A lot of times it's no big deal or it's a very small deal, but just understand it could end up being quite large for any number of reasons. But most of the time, it may not be zero, but it is likely the stakes are not going to be quite this high. So that's it. We got Bo here going, I always knew Bob was a liar and a cheat. Hopefully he finally gets what he deserves. Come on, Bo's the bad one, not me. Tracy made me do it. Well, I really do hope that's a helpful lesson. As always, like and subscribe if you find it helpful, and if you want to stay in the loop. I'd appreciate that very much, and thank you so much, and I'll be back with more very soon. Bye.